On design and construction projects, the right way to think about contracts is an interrelated web of agreements to design and construct a project rather than a bunch of isolated documents that stand on their own. If you negotiate a design or construction contract without bearing in mind where it fits within the larger web of agreements for the specific project, you're really negotiating the contract with one eye closed. Because design and construction is a team sport. More so than any other type of contract that I've seen, in the design and construction industry, it is common for one party's contract to set forth certain assumptions that are going to be met by other people, people with whom perhaps they have a contract, but possibly people who are several links in the contractual chain away. And so it is important to think about what are all the obligations of the various parties and have they been tied up in a good agreement that fits within the broader web of construction contracts. Because they're not just about project execution. Part of this is certainly about if the expectation is that payment is going to be made within a certain amount of time, it's a good idea if the other agreements that require a party to look over an application for payment require them to act promptly within that time frame so that the expectation can be met for when the payment will actually be made. Yes, of course, those things are important, and I can think of dozens of examples of project execution related roles that parties will have contractually to fill in order that everybody else can have their expectations met. But when it comes to claim time, in those unfortunate projects where there is a claim, it can be a big mistake for the parties to look at their contracts and to realize that they were not well coordinated. And I can give you a few examples. One in particular relates to intellectual property. A lot of times I will see agreements between real estate developers and project owners and their design professionals, architects and engineers, which require the owner of the project to become the copyright owner of the intellectual property, of the instruments of service that are prepared by the design professionals. And if the architect in the owner-architect agreement promises copyright ownership of the entire design to the owner, but the architect itself failed to obtain copyright ownership from its subconsultants, if the architect has, for example, only a limited license to use those works, as soon as the architect promises copyright ownership upstream in the owner-architect agreement, the architect has breached its contract right out of the gate. As soon as they lift the pen off the paper, they've breached their contract because they've promised something to the owner, copyright ownership in their subconsultants' designs, that they lack the ability to confer. Payment-related terms are another one. It's very common for a real estate developer or a project owner to need to take a payment application not just to their project manager, but to their joint venture partner, to their investors, to their lenders, their title insurers, and sometimes the process of reviewing those payment applications can take time. And it can take extra time if it is a project where there isn't a stipulated sum or a fixed fee, but rather the compensation of the contractor is based upon the cost of the work up to a guaranteed maximum price. And so when an owner signs an agreement with a contractor for construction, the owner needs to be thinking about how long do they logistically need in order to run the payment application through all of the various sets of review in order for it to be blessed and so that the green dollar bills can fly out in the direction of the contractor's wallet. Another place where owners and contractors really need to be careful to make sure that there is an understanding and consistency within agreements is with respect to insurance. And of course, additional insured coverage is very important, but I'm thinking more about builder's risk. A lot of project owners do not understand that a builder's risk policy, which is a kind of property insurance policy that covers problems that could happen, calamitous events, fires, explosions, property damage during the construction itself, doesn't just protect the owner, it also protects the contractor. And in a number of standard form agreements, the owner is asked to make certain promises about the sorts of insurance that they are going to carry, not just for their own risk, but also to protect the contractor. And if the project owner does not understand the meaning of the terms within their contract, and they fail to get the insurance that they're promising to procure for the contractor by contract, then again, as soon as they've finished signing the agreement, they've already breached it right out of the gate. Another place where consistency in agreements between the various webs of contracts for a project is in dispute resolution terms. And what I'm talking about is whether or not you're going to resolve a dispute through litigation on one hand, or the other binding method of alternative dispute resolution, arbitration. And what most of the time you want, not every time, but most of the time what you want is for all of the agreements on a specific project to pick the same method of dispute resolution. If the owner-architect agreement picks litigation, there's a lot of reason why the owner might want the owner-contractor agreement to also select litigation. And the reason is because if you wind up in a dispute with multiple parties, it's useful to get everybody who could be potentially liable before the same decision maker, whether it's a court of law or whether it's an arbitration panel. Because if you are, for example, an owner that has an obligation to arbitrate with the architect and litigate with the contractor, in the event that you have a claim where there's some dispute about who's responsible, you might have to go to litigation on the one hand, and see that claim all the way through, take the result, and then try to replicate it in a separate arbitration. Now, not only is that going to be twice the cost and twice the hassle, you could have inconsistent outcomes. You could lose in both forums. The court, where you're suing the contractor, might find that it's the architect's fault, and the arbitrator, where you're bringing a claim against the architect, might find that it's the contractor's fault. And so among the many places within this web of design and construction contracts where people want to be thinking about consistency, it's not just intellectual property, it's not just payment terms, it's also consistent dispute resolution terms, and frankly, a myriad of other terms that cross throughout this web of design and construction terms for any given project.